Hello everyone, my name is Aaron Woodman, and I want to welcome you to my YouTube channel. In this video, we are going to provide a recap of this video set series on the interpretations of free speech rights. Throughout this video set series, we analyze important free speech rights from the First Amendment by looking at how the Supreme Court looked at specific free speech issues, what arguments they heard in those cases, and how they ruled on those cases that impacted our free speech rights. This is important because the way the rules are set up affect what we can say, how we can say certain words, and where we can say them. The judicial branch interprets the Constitution and the provisions in it. The Supreme Court rules if specific actions and laws are constitutional or not. Because of all of that, we need to understand what the Supreme Court's rulings on free speech are and how they impact the way we conduct ourselves in public when it comes to speaking up and speaking out on different things. Whether we agree or disagree with the rulings, what matters is how we use those interpretations to navigate our society and free speech rights. Let's go over the topics we covered in this video set series. We talked about your right to advocate for illegal action unless it likely causes imminent harm. We explored the case of Molly Steimer and other anarchists who protested U.S. actions in Russia during World War I. After distributing leaflets urging factory workers to strike, they were arrested and convicted under the 1918 Sedition Act, which criminalized speech critical of the government. Their case, Abrams versus United States, reached the Supreme Court. The majority upheld the convictions based on earlier wartime rulings that restricted speech, such as Shedneck versus United States. However, in Abrams, Justice Holmes radically changed course in a dissent that argued that speech should only be punished when it presents a clear and present danger of immediate harm. His dissent emphasized the importance of a free trade in ideas and warned against punishing speech simply because it is offensive or unpopular. Holmes's ideas were later played out into the modern rule announced in Brandenburg versus Ohio, where speech advocating for illegal conduct is protected unless it is directed to and likely to produce imminent lawless action. We talked about your right not to be compelled by the government to speak about a certain thing. We explored the case of siblings William and Lillian Gobaitis, who refused to salute the flag because their faith considered that action idolatry. After they were expelled from school, their family took the case to court. Although the lower courts ruled in their favor, the Supreme Court reversed those decisions in Minersville School District versus Gobaitis. Justice Felix Frankfurter argued that patriotism was essential for national unity during turbulent times. Justice Harlan Stone was the only dissenter, insisting the government cannot force citizens to say what they believe. After the ruling, there was widespread harassment and violence against Jehovah's Witnesses nationwide. Over 2,000 children were expelled. 3 years later, another similar case arose involving Maureen and Gathy Barnette in West Virginia. This time, the lower court rejected Gobaitis, and when the case reached the Supreme Court as West Virginia versus Barnette, the Supreme Court overturned Gobaitis entirely. Justice Robert Jackson's majority opinion declared that the government may not compel speech. He emphasized that the First Amendment protects the, quote, sphere of intellect and spirit, unquote, from official control, and that freedom of thought is fundamental to our rights. The Supreme Court held that no government official can force people to salute the flag or say the pledge. This decision became a landmark case in defining compelled speech protections. We talked about your right to criticize public figures and make mistakes. We explored a civil rights fundraising advertisement in the New York Times praising student sit-ins, describing harsh police responses in Montgomery, and asked for donations to support Dr. Martin Luther King Jr. This was in the 1960s. Although the ad did not name him, Montgomery City Commissioner L.B. Sullivan sued the Times and several civil rights leaders for libel, where he claimed the statements implied he committed misconduct. Despite minor factual errors and little evidence of reputational harm, an all-white Alabama jury awarded Sullivan $500,000. Additional lawsuits followed and threatened to bankrupt the Times and silence reporting on the civil rights movement. The Supreme Court took the case, and in the New York Times versus Sullivan They held that public officials must meet a new high standard to win a libel case: actual malice. This means the plaintiff must prove the speaker knew the statement was false or acted with reckless disregard for the truth. Justice Brennan's majority opinion emphasized that public debate must be, quote, uninhibited, robust, and wide open, unquote, even when it includes harsh criticism of officials. Because the ad was not intentionally false and was not specifically of and concerning Sullivan, the previous rulings were reversed. The actual malice standard protects journalists, activists, and everyday citizens from being punished for honest errors when speaking about public officials. It ensures the press can investigate powerful people without fear of massive lawsuits designed to intimidate or silence them. At the same time, the rule does not protect deliberate lies, where knowingly publishing false statements remains legally punishable. We talked about your right to non-destructive protest in school. We explored the story of Mary Beth Tinker, her brother John, and fellow student Christopher Eckhardt, who wore black armbands to protest the Vietnam War. Although the students caused no disruption, school administrators suspended them under a newly created ban aimed specifically at armbands. With support from the Iowa Civil Liberties Union, the families challenged the policy in court. Despite facing threats and anger, which was common during a time when most Americans still strongly supported the Vietnam War, the students persisted. Lower courts sided with the school district, where they accepted the argument that administrators needed broad power to prevent possible disturbances. The case eventually reached the U.S. Supreme Court, called Tinker v. Des Moines. The student's attorney argued that the school banned only the viewpoints it disliked, which the district claimed the armbands could spark unrest. The Supreme Court ruled 7-2 in favor of the students, declaring that students do not, quote, shed their constitutional rights to freedom of speech or expression at the schoolhouse gate, unquote. Justice Abe Fortas emphasized that fear of disruption is not enough. Schools must show a reasonable forecast of substantial disruption before restricting student expression. Tinker became the foundation of modern student speech rights. While later cases allowed schools to restrict vulgar and other inappropriate speech, Tinker's core holding remains. Students may express political views as long as their protest does not materially disrupt school or infringe on the rights of others. We talked about your right to offend. We explored the story of Paul Cohen, who was arrested for wearing a jacket with the phrase "F the draft" in a courthouse. Although he caused no disturbance, he was convicted under a California law against offensive conduct. His conviction was upheld by the state court, which claimed that vulgar political language could endanger public peace. During oral arguments before the Supreme Court in Cohen v. California, Cohen's lawyer, Melville Neimer, deliberately spoke the expletive aloud to show that offensive language does not inherently cause disorder. He argued that emotional expression is part of meaningful speech and that censoring offensive words would also suppress unpopular ideas. The Supreme Court agreed in a 5-4 decision. Justice John Harlan's majority opinion held that Cohen's jacket was protected speech. It was not obscene, threatening, or directed at any individual. The ruling established two major principles. One, offensive speech, including profanity, is fully protected by the First Amendment. Two, speakers may choose a language, emotive or explicit, that they believe best conveys their message. Essentially, individuals may legally express offensive political messages in public and not get punished by the government, as long as they do not engage in threats, incitement, or defamation. We talked about your right to punish without being stopped by the government. We explored the background of the Pentagon Papers, a 7,000-page top-secret Defense Department study revealing decades of government deception about the Vietnam War. Daniel Ellsberg leaked the documents after Congress refused to release them. Despite warnings that publishing them risks criminal charges under the Espionage Act, the New York Times began publishing excerpts in June 1971. The Nixon administration, fearing political damage and believing laws had been broken, took the unprecedented step of trying to stop the newspaper from publishing. The government demanded a court order, a prior restraint to prevent further articles from being made on these excerpts, arguing that publication would harm national security. A temporary injunction halted the series, but both the Times and later the Washington Post continued to fight in the case in court. The Supreme Court agreed to hear the case in the New York Times company versus United States. The government argued that publication would cause irreparable harm to national security. The Times countered that prior restraints are almost never constitutional and that the First Amendment exists to let the press expose government wrongdoing. In a 6-3 decision, the Supreme Court ruled for the Times and lifted the injunction. The justices held that the government had not met the extraordinarily high burden required to justify censoring the press. Justice Black's opinion emphasized that a free press exists to serve the people, expose government deception, and prevent officials from misleading the country into war. This ruling established that the government cannot stop the press from publishing unless publication would surely cause direct, immediate, and irreparable harm to the nation. We talked about not having the right to curse on broadcast television and radio. We explored George Carlin's 1972 quote, 7 words you can never say on television, unquote, which sparked public controversy and eventually led to a complaint filed with the FCC after a radio broadcast of the routine. Although the FCC cannot censor content outright, it can regulate indecent material on public airwaves, especially when children might be listening. The dispute escalated into a Supreme Court case called FCC versus Pacifica Foundation. In a 5-4 decision, the Supreme Court ruled that the FCC had the authority to restrict patently offensive language dealing with sexual or excretory content during hours when children might be in the audience. This became the legal foundation for indecency rules in effect today, which prohibits such language on broadcast stations from 6 a.m. to 10 o'clock p.m. Over the years, the FCC has issued fines for indecent language and even brief nudity. Later Supreme Court cases, such as FCC versus Fox and FCC versus CBS, limited the FCC's ability to penalize broadcasters without clear notice, but left the Pacifica framework intact. Importantly, these rules do not apply to cable or streaming networks because they are subscription services rather than public airwaves. We talked about your right to parody. We explored Hustler magazine publishing a parody of a Campari advertisement featuring evangelicus Jerry Falwell in a fake interview describing a drunken sexual encounter with his mother. The ad was intentionally outrageous and impossible to take as fact, but Falwell used it to rally supporters and sued Hustler founder Larry Flint for libel and intentionally infliction of emotional distress. At trial, the jury rejected Falwell's libel claim because the parody could not reasonably be understood as stating actual facts, but they awarded him damages for emotional distress. On appeal, the Fourth Circuit upheld the emotional distress verdict, prompting Flynn to take the issue to the Supreme Court in a case called Hustler Magazine versus Falwell. Before the Supreme Court, Flynn's attorney argued that public figures should not be able to sidestep the New York Times versus Sullivan's actual malice standard by relabeling their injury as emotional distress. The justices questioned both sides intensely, probing the limits of satire, public discourse, and emotional harm. In a unanimous decision, Chief Justice Requisite ruled for Hustler. The Supreme Court held that a public figure cannot recover damages for emotional distress from a parody or satire unless it contains a false statement of fact made with actual malice. Because the ad could not reasonably be interpreted as factual, Falwell's claim failed. The ruling emphasized that parody, however crude, offensive, or intentionally hurtful, is vital to political and social commentary, such as criticism and humor. We talked about your right to espouse thoughts people hate. We explored the Westboro Baptist Church, where they have done anti-gay protests at funerals of people who had died of AIDS. After Marlene Lance Corporal Matthew Snyder was killed in Iraq in 2016, Westboro picketed his funeral with hateful signs. His father, Alvarine Snyder, who was privately gay, was devastated and sued the church for intentional infliction of emotional distress. A jury awarded him over $10 million, but the Fourth Circuit Court reversed the verdict, ruling that Westboro's speech addressed matters of public concern and was protected by the First Amendment. The Supreme Court decided to hear this case in Snyder versus Phelps. The Supreme Court ruled 8-1 that Westboro's speech was protected because it addressed public issues, occurred peacefully on public property, and did not disrupt the funeral. Chief Justice John Roberts emphasized that the First Amendment protects even hurtful and vicious speech to prevent the government from censoring ideas simply because it finds them offensive. Lastly, we talked about your right to use social media as a public forum. We explored Lester Pakenham, who was on the sex offender registry for a crime committed years earlier and celebrated beating a traffic ticket by posting on Facebook. North Carolina had a sweeping law that made it a crime for registered sex offenders to access any social media site that allowed minors. Pakenham was discovered under the alias arrested and convicted despite having no unlawful online contact with minors. On appeal, the Court of Appeals of North Carolina struck the law down as overly broad, but the North Carolina Supreme Court reinstated it, claiming offenders could use alternative websites. The U.S. Supreme Court agreed to hear the case, which would be called Pakenham versus North Carolina. During oral arguments, the justices focused heavily on the role of social media in modern life. Justices Kagan, Kennedy, Ginsburg, and others pressed the state on how the law blocked access to vital spaces for political, social, and religious communication, like social media platforms used by government leaders and millions of Americans. They emphasized that social media functions as today's public square. In a unanimous decision, the U.S. Supreme Court struck down the law. Justice Kennedy wrote that the internet, especially social media, is now one of the most important forms of free speech, learning, political participation, and community life. While protecting children is a legitimate state interest, the law must be narrowly tailored and must not, quote, burden substantially more speech than is necessary to further the government's legitimate interests, unquote. The Supreme Court emphasizes that states can still pass targeted laws that prevent harmful conduct, such as contacting minors or gathering information to commit crimes, but they cannot broadly prohibit lawful participation in online life. The ruling recognizes social media as a public forum for First Amendment purposes, but social media platforms themselves are private companies, where they are free to moderate, ban users, and control content however they choose. Section 230 protects these companies from liability for user posts, enabling the modern internet to function. Although the Supreme Court protects access to these platforms, it offers no solutions for issues like hate speech, harassment, false information, or extremist content online. So, you now know the main interpretations of free speech rights we have, as well as the arguments for and against these specific types of free speech rights mentioned in each of these Supreme Court cases. While it certainly does not cover every single circumstance of free speech issues that can potentially rise up in our lives, we still have a good understanding of what types of speech we are protected from government overreach. We know that we can say things that can be controversial to some people and not get shut down simply because someone disagrees with our opinions and viewpoints. We know that we can have access to important records that hold the government accountable, no matter if those records show our government officials are committing wrongful conduct. We also know we need an environment that fosters us to share information and ideas we have to debate and persuade each other on the direction of how our society should go. As long as our speech does not cause physical violence and does not jeopardize the functioning of society, we can exercise our First Amendment rights. Knowing these Supreme Court cases and their rulings help guide us in using our free speech rights and gives clarification on making sure they do not get violated. Being civically engaged involves knowing the rules set out by our judicial system, since it is designed to resolve legal disputes and explain how the Constitution applies in our lives. This officially concludes the video set series on the interpretations of free speech rights. I will begin uploading a new video set that goes in depth with another topic in my civic engagement curriculum. But until then, please like this video, subscribe to my YouTube channel, and turn on the post notifications so you will be notified when I post my next video. I appreciate your support. Remember, you are powerful, you are capable, and you are the change maker our society needs. Thank you so much for watching this video. I will see you soon.